Good afternoon. Thank you so much for joining us today for our presentation on an overview of New York Sick and Safe Leave Program requirements. My name is Casey Cohn, and I work in the HR consulting area of OneGroup. With me today are Brianna Sweeney and Rachel Wisely, both of whom also work in the HR consulting area of OneGroup and have been following the developments of this new law since April. We want to thank those who have submitted questions in advance of the presentation. We were able to incorporate many of the questions within the presentation and have also reached out to some of you individually as well. For those with additional questions, we will provide an email address at the end of the presentation that you may use to submit questions. Before we get started, I also wanted to mention our disclaimer that our presentation is for informational and educational use only. OneGroup provides information, research guidance, and best practices, but does not offer specific legal or tax advice. OneGroup services are not intended to be a substitute for legal or tax advice, and given the changing nature of federal, state, and local legislation, and the changing nature of court decisions, we cannot guarantee that the information will not change in the future. It is recommended to seek legal counsel or tax guidance if such guidance is warranted or preferred. This presentation provides an overview of the available guidance on New York State Sick and Safe Leave Law. Information in this presentation is subject to change as interpretive guidance and final regulations are issued from the New York State Department of Labor. For our agenda today, we will be discussing the timeline of events, the summary of the basics, considerations of how to edit current PTO policies, frequently asked questions, and also share where to submit your questions. So the timeline of events, how did we get here? On April 3rd, 2020, Governor Cuomo signed the 2021 state budget into law, which included provisions for an expanded paid sick and safe leave program. The actual law went into effect on September 30th, and then on October 19th last week, New York released some guidance under the law. The new sick and safe leave provisions will require that private New York employers of all sizes provide a certain amount of either paid or unpaid sick and safe leave to be used for certain reasons. The law did go into effect on September 30th. However, employees are not entitled to use leave until January 1, 2021. No guidance was issued last week. However, we are still anticipating the release of proposed and final regulations within the coming months. So stay tuned, definitely more to come. Now we'll go through a little bit of the basics. So who is eligible? As I mentioned, the law applies to private sector employers. So public sector employers are excluded. Federal, state, and local government employees are not covered, but employees of charter schools, private schools, and not-for-profit organizations are covered. Under the legislation, generally all employees are entitled to accrue the sick and safe leave. This will certainly be a change for many of you, as this does include part-time, seasonal, exempt, per diem, and temporary individuals. So really anyone that's an employee is eligible to earn or accrue the sick and safe leave. So generally, if you issue a W-2 to an employee, they are an employee and they are entitled to the leave. So the amount of leave, there's 4 different buckets that a private employer could fall into to determine the appropriate amount of either paid or unpaid sick and safe leave to provide. So those with fewer than 5 employees and a net income of less than $1 million in the prior tax year are required to provide 40 hours of annual unpaid sick and safe leave time. For those with 4 or fewer employees and a net income of greater than $1 million in the prior tax year, that would be 40 hours of paid annual sick and safe leave. Those with 5 to 99 employees would be 40 hours of paid annual sick and safe leave, and then 100 and more employees would be 56 hours. So really for some, it will be an annual assessment to determine the number of employees. So those that are either on the cusp of one of those, one of the 4 different buckets really should take an annual assessment to determine the appropriate bucket that you fall into. More information is expected to come with regards to exactly how employers count their employee size. So whether that's looking at an entire year, a specific time frame, different pay periods, more information to come. But at this time, what we know is that employers do have to go back 12 months, and that 12-month period is defined from January 1 to December 31 in order to determine their appropriate size. So once you determine the amount of sick and safe leave that you are required to provide, then it's the option of choosing how to provide that time. So employers can choose to either front load, which is granting all the time at once each year, or allow employees to accrue at a rate of 1 hour per every 30 hours worked. So there's certainly positive and negatives based on each employer's specific situation and to determine how to provide that time. So generally, if you're going to provide the front load methods, you give all the time upfront each year for all employees. You can't revoke that time later on in the year if it turns out that that employee doesn't work the amount of time that you thought that they would, or they turn to part-time status. So once it's provided, you can't take it back. On the flip side, if you are accruing that time, so employees actually have to earn, the 1 hour per every 30 hours worked, that means you have to track everyone's hours worked, which includes your exempt employees. So for those where you might not have tracked actual hours worked, if you are going to allow them to accrue the time or provide the time from an accrual method, you do have to now track all of their hours worked. And then certainly nothing prohibits or prevents an employer from providing an amount of sick or safe leave in excess of the requirements. So these are the requirements that we're talking about, but certainly if you have a more robust paid time off policy, which many employers do, you can certainly provide that as well. The guidance, the recent guidance that was issued did talk about front-loading time for part-time employees. So there are some options there with your part-time folks. So the guidance indicates that you can front-load the time based on their anticipated schedule or their anticipated number of hours that they are expected to work. So you can certainly do that. However, you can't, you still have to track that part-time employee's hours worked. In the event they work more than what was anticipated and therefore they're owed extra time, you do have to allow them to accrue that additional time that they should be entitled to. Some additional considerations to think about as you're looking at your current policies and implementing the new policy or the new program is that accruals really should be retroactive to September 30th. That was the date that the law went into effect, and that's the date that employees were required to begin accruing their time. So accruals should be retroactive to September 30th, 2020. With that, employees have to be allowed to use any accrued time beginning January 1. For the purposes of providing the sick and safe leave, a calendar year could mean a 12-month period from January 1 to 12/31, or a different type of 12-month period, such as anniversary dates, different determinations to determine how to provide that sick time. So you do have, employers have the option to determine that 12-month period. Waiting periods for new hires are not permissible as there's no minimum amount of time required for an employee to work. It's really once they earn that time, they're eligible to use it. If it's front loaded, they can use it right away. As they earn it, they do have to be able to use it. So some policies typically might have a 30 or 60 or 90-day waiting period for new hires to be able to use the time, and that will no longer be permissible under this law. And certainly a written policy, including all of the parameters and any restrictions, should really be posted and distributed. We certainly recommend including it in the handbook and having employees sign off on it that clearly lists out what the policy is as far as what employees are entitled to receive and certainly any restrictions within that, and of course, making sure it's all compliant with what's required. So at this time, I will turn it over to Brianna.
Thank you, Casey. So now I will discuss the reasons for use. So this law is divided into two different types of leave, sick and safe leave. So in regards to sick leave can be used for a mental or physical illness, injury, or health condition, and that can be used for an employee or an employee's family member. So the most important item to take away from this slide is that sick leave is not only for use by the employee specifically, but it can relate to the employee's family member as well. In a few slides, I will discuss the definition of an employee's family member and who will fall under that definition. But also to note, regardless of whether the illness or injury or health condition has been diagnosed or requires medical care at that time that the employee requests such leave, as well as for the diagnosis, care, and treatment of the mental or physical illness, injury, or health condition, or the need for medical diagnosis or preventative care. And again, for the employee or employee's family member is the reason for use for sick leave. And then the second type of use or bucket would be for safe leave. And that would be reasons for a victim of domestic violence. This could be a family offense, sexual offense, stalking, or human trafficking. And just like for sick leave, this type of leave would also apply to reasons related to family members of the employee as well. This law gives various instances listed on the slide that would qualify an employee for leave under the law. I won't read all of these word for word, but a few examples would be if the employee or the employee's family member needed to obtain services from a domestic violence shelter to participate in safety planning. Possibly this could include something like taking self-defense classes. If the employee or employee's family member needed to meet with an attorney. And then finally, the final definition, and it's very broad, would be to take any other actions necessary to ensure the health or safety of the employee or the employee's family member, or to protect those who associate or work with the employee. These are all reasons for use under the safe leave provision of the law. So now the definition of a family member. So family member, and as I mentioned before, it can be used for both leave under both sick and safe, is defined as the employee's child, spouse, domestic partner, parent, sibling, grandchild, or grandparent, and the child or parent of an employee's spouse or domestic partner. And then to further define that, parent would be biological father, step, adoptive parent, or legal guardian of the employee, or a person who stood in loco parentis when the employee was a minor child. And then child is also biological, adopted, foster, legal ward, or a child of an employee standing in loco parentis. So now moving on to just some additional requirements in regards to use. So under the law, employees are permitted to require employees to use their leave in increments of time. However, that increment of time cannot exceed 4 hours. So this doesn't necessarily mean that the employee cannot take more than 4 hours or sick or safe leave at once. It just means that increments of 4 hours or less is what is allowed under the law for the employee to require how much time that the employee take that time in. So if the employer chooses, employees could take increments of leave, for example, in 15-minute increments, 30-minute increments, an hour, whatever the employer chooses, just as long as it's in an increment of 4 hours or less. And if the employee needs to use an entire day of leave, that would be permissible as well. The law just states that the maximum increment is 4 hours at a time. Another question, and we have received a lot of these questions, is in regards to how much advance notice can employers request employees give prior to taking leave. So under the law, all the notice that is required is that there is an oral or written request to the employer prior to using any accrued sick or safe leave. So as long as an employee gives prior notice, and that could be a half hour before a shift, the day before a shift, but as long as they give prior advance notice to the start of their scheduled working shift, this would be compliant under the law. We are hopeful that the state will release additional guidance regarding this topic. However, at this time, this is all we know to date. Ultimately, an employer can request, however, not require, based on current issue guidance. It can be requested that employees give as much advance notice as possible prior to taking sick or safe leave. However, it would generally not be permissible for an employer to discipline an employee for not giving enough notice, as long as they gave advance notice prior to their start of their shift. So in addition to the questions about requiring prior notice, we also have received a lot of questions about what can employers ask or require from employees regarding the reason for their need for leave or why they're taking leave. So under the law, an employer may not require the disclosure of confidential information, and that's relating to mental or physical illness or injury. That would be specific to the sick leave aspect, as well as the reason due to domestic violence. That would be to the safe leave aspect. Unfortunately, the state did not clearly define what exactly confidential information was. So that's another area that we're still waiting for further guidance on. So we're not entirely sure what exactly an employer can request or require in terms of documentation and information for why an employee would need such leave. And then finally, when it comes to using sick leave, an employer cannot mandate that employees telecommute from home instead of using sick or safe leave. And I believe this kind of question, why the state addressed this, is mainly due to the recent pandemic and with a lot of employees working from home. This certainly is an option if employees, if the employer and employee can mutually agree that telecommuting from home would be beneficial and work for both parties. It certainly is an option. If the employee is in a situation where they feel well enough or able to work from home, then they certainly have the option to telecommute instead of taking safe and sick leave. In the instant that employee works from home, then they would be compensated for the time that they worked and would be able to save their sick and safe leave day, and then that could be used at a later date. All right, so payment of sick and safe leave. So employees must be paid for sick and safe leave at their regular rate of pay. Employers are not required to pay employees for any lost tips or gratuities. But just note, employers may not take a tip credit for leave time and must pay employees their normal rate of pay, or the applicable minimum wage, whatever is greater. And then when employees are paid on a non-hourly basis, you would figure out the accrual of sick and safe leave by measuring the actual length of time that's spent performing work. And employees sometimes are paid at more than one rate of pay. An example might be where an employee is paid, their travel time might be paid at minimum wage, but their actual working time is a normal rate, for example, $20 an hour. So you would have to figure out the weighted average to figure out what their regular rate of pay would be. So the weighted average is the total regular pay divided by the total hours worked in that week. And then another important item to note is that if an employee is required or would be working overtime on a day that they're taking sick or safe leave, the employer would not have to pay the overtime rate for that time. They would just have to pay the regular rate. So overtime would not have to be paid for hours that are taking paid sick leave, even if they would be overtime hours for that scheduled day. So moving on to carryover. So under the law, all unused accrued sick and safe leave has to be carried over into the next calendar year. Then immediately upon carrying over any time, the employee would then begin to accrue sick leave for the new calendar year or be front loaded, and that would be dependent upon whatever method the company is using. So it's important to note that there's not a cap on the amount of time that can be carried over. However, there is a cap on the amount of usage. So this means that employees can be limited to using either that 40 or 56 hours, and that would be dependent on your employer size. But carryover does not currently have a cap. So if an employee does not use any of their time, so they have the 40 hours, they don't take any paid sick leave, any sick or safe leave for the entire year, then they would have to carry over all 40 of those hours. And then they would be awarded, if you're using the front load method, another 40 hours in the next calendar year. So they would have a total of 80 hours to use, but you can limit how much time they use in the calendar year. So even though they have 80 hours of sick and safe leave in their bank to use, they wouldn't necessarily be allowed to use all 80 hours. You would just have to document and track that the time was carried over, that they do have the time, even though they may not necessarily have to use the time. So the reason for that, the state indicated that the reason for carryover, why they think carryover is necessary, is so that if using the accrual method, employees will have time immediately available to use instead of having to wait to accrue. So if employees carry over a little bit of time, then they wouldn't have to wait to accrue time. They would have it immediately available to use to them. We're anticipating either an update or some further clarification regarding carryover from the state down the road, but to date, all unused time must be carried over. So moving on to documentation tracking, as I kind of mentioned in my last slide, the employers must track how much sick and safe leave their employees have used and accrued, and that must be in the current calendar year and or in any previous calendar year. And the reason for this is any information must be provided upon oral or written request of the employee, and that must be provided within 3 days of the employee's request. So that's why it's important that you're tracking how much time the employees have used, and that would apply for both exempt, non-exempt, all classes of employees, because if an employee comes to you and wants to know how much time they have available, you have 3 days to provide that information to them. So in accordance with the labor law, an employer is required to maintain and preserve accurate records for each work week. And this would be showing the amount of sick leave provided to each employee, and this is for 6 years. So an employee's weekly payroll records must include the amount of sick leave provided to each employee. The amendment doesn't require employees' pay stubs to include the sick and safe leave information, but you do just have to preserve those records for 6 years. So that is the record retention rule, and that was an amendment to the labor law that recently was updated. So moving on to the no discrimination requirement. So this is part of the law, and it indicates that no employer shall discharge, threaten, penalize, or in any other manner discriminate or retaliate against an employee because such employee has exercised his or her rights under the law. So exercising rights is defined as requesting sick or safe leave or using sick or safe leave. So ultimately, you cannot discriminate an employee for using, requesting sick or safe leave. And there are certain aspects when reviewing your policies that could be viewed as discriminatory. So there are, when reviewing your policies, you want to make sure that nothing in your policy would discriminate or be viewed as retaliatory when revamping your policies to be compliant under the new safe and sick leave law. And moving on to job restoration. So if an employee takes sick and safe leave, they have to be restored to their position of employment prior to any use of safe or sick leave, and it must be the same pay and other terms and conditions of employment. Retaliated against, they have to be restored to the same position. And finally, moving on to penalties. Now to discuss what would happen if an employee does not comply with the law. Penalties for discrimination or retaliation allow an employee to possibly bring a civil action or file a complaint with the New York State Department of Labor. Failure to provide employee benefits such as sick and safe leave is basically equivalent to failure to pay employee wages. So those found in violation may be subject to civil administrative actions or criminal penalties. This is including but not limited to an order assessing the full amount of the wage of underpayment, 100% liquidated damages, and civil penalties in an amount up to double the total amount to be due. So there are penalties should an employer be found to not be in compliant with the law. So now I will pass it over to Rachel, who will discuss Westchester County sick leave.
Thank you, Brianna. And I'm going to start out with the Westchester County law. So this slide only applies to employers in Westchester County. And as you may be aware, Westchester County has their own sick leave requirement, and New York State has issued an FAQ that just relates to the interaction of these two laws with the Westchester County and the New York State law. And this is what has been released thus far. Westchester County currently provides that domestic workers accrue sick leave at the rate of 1 hour for every 7 days worked and earn and can use up to 40 hours of paid sick leave per year, regardless of the size of the employer. These benefits will continue to be available to domestic workers in Westchester County. So what that means is employers of domestic employees in Westchester County must grant both the county leave and the New York State sick and safe leave. And that is all that has been clarified thus far. So we just wanted to share that. And then these next few slides will be about the New York City safe and sick leave updates. So they really only apply if you have employees in New York City. But there recently has been some updates to the New York City paid sick leave law to bring that law into compliance with the state law. And there were also some additional changes made to the New York City law specific to New York City. So I'm just going to run through those. So per the New York City Department of Consumer and Worker Protection, effective September 30th, New York City employers must provide domestic workers with 40 hours of paid safe and sick leave. And this basically means that all New York City employees are covered under this law now. Previously, the law was only employees that worked 80 hours or more in New York City, but now there's no time requirement either. So now basically all New York City employees are covered. And the next, allow employees to use safe and sick leave as it is accrued. This is also a change because previously there was a waiting period allowed in New York City. And next, reimburse employees who must pay for required medical documentation after 3 consecutive workdays of leave. So for example, this would mean if an employee had to pay at their doctor's office to get specific forms filled out, now you must reimburse employees for those expenses. And this is one of the bigger changes. New York City employers must now list on employees' pay stubs or any document issued each pay period the amount of accrued and used leave and the total balance of accrued leave. So this has to be in place by November 30th of 2020. The actual documentation requirement goes into effect on September 30th, but the commission has decided to be a little lenient for employers and give them a little bit of a grace period in order to just give them time to update their payroll records to get that information listed on employee pay stubs. So New York City employers have until November 30th to have all that information listed on employee pay stubs. All right, and just another change with the New York City law, employers with employees in New York City must also provide and post written notice of the amended New York City law to all New York City employees within 30 days of its effective date. So that would be October 30th, or on the employee's date of hire, whichever is later. And actually, just this morning, the Department of Consumer Affairs released the updated Notice of Employee Rights. So that is available on newyorkcity.gov for distribution to employees by tomorrow. And also effective January 1st, 2021, employers with 100 or more employees must provide up to 56 hours of paid leave, and employers with 4 or fewer employees and a net income of 1 million or more must provide paid leave under the New York City law. All right, now back to the New York State law. I'm going to just touch on the collective bargaining agreements. And the law further provides that collective bargaining agreements entered into on or after September 30th may provide for different leave benefits. So long as such employees are comparable, so long as such benefits are comparable benefits for the employees to those required by law, and the agreement must specifically acknowledge Section 196B of the labor law, and that is the section where the sick leave requirements are. So this acknowledgement should also just specifically identify any benefits that they deem comparable to the sick leave law. So those should be listed right in the acknowledgement. And to satisfy the requirements of the law, any agreement entered into or after September 30th, 2020 must specifically reference that labor law. So you want to make sure that your collective bargaining agreements reference the labor law and also acknowledge any benefits that are deemed comparable to the labor law. So more to come. There are some additional regulations to be published by New York State that we're hoping will ideally address how to calculate employer size, how to calculate net income, further clarifications regarding the calculation of the regular rate, if employers can require documentation justifying the need for leave, and also the definition of confidential information. And we also anticipate that some additional FAQs will come out periodically on the state's website. So we just encourage all employers just to continue to check the website for periodic updates. And we will also send out updates to our clients when we see that any additional FAQs or information has been posted. All right, moving on to interplay with existing PTO policies. So these are just some considerations for employers when they are reviewing their current policies. Existing PTO and sick leave policies must be updated to account for the safe and sick leave law, and with special attention paid to accrual, carryover, and use. So all policies should be updated to reflect all aspects of the sick leave law. And the first bullet is just to pay attention to accrual amounts, carryover amounts, and use information. These are crucial. These are the key components that will need to comply with the sick and safe leave law. So that would be the accrual has to be 1 hour per 30 hours worked, or the front loading of at least 40 hours or 56 hours, depending on your employer size. Carryover needs to be mandated, and also the use information, which could include the reasons for leave. And in existing policies, even if they meet that hours requirement, they should explicitly be modified to include those uses of leave. So those would be the reasons that Brianna touched on earlier. You want to make sure those are in your policy, so your employees know that their PTO policy also covers their sick leave, so they know their reasons for leave under the sick and safe leave law. And you also want to include definitions of relevant terms, and this could including the definition of a family member right in your policy. And policies should also prohibit discrimination, harassment, retaliation for employees who use the leave or make a complaint of the same. And also you want to make sure that policies should reflect other leave law policies in your handbook, paid or unpaid, such as the Family Medical Leave Act, FMLA, New York PFL, paid family leave, and also any collective bargaining agreements. And those policies should be modified to reflect the sick and safe leave as well. So that really means we just suggest reviewing any of your company leave policies and update them as needed to address any interplay with the sick and safe leave law requirements. Additional considerations. So these are just some questions that you can ask yourself when you are reviewing your company policies for compliance with the sick and safe leave law. So the first one is there a waiting period for new hires to begin accruing or using sick and safe leave? And waiting periods are not permissible, so you just want to make sure that the waiting period is removed when updating your policy. The next is medical documentation required if an employee has been out of work for X amount of days? And medical documentation after being out for a certain number of days would generally not be permissible under the current guidance, so you would want to make sure to update your policy to reflect that as well. Next, you have an advance notice requirement to use time off. And do you penalize your employees if they do not follow these requirements? And penalizing an employee for not following advance notice requirements would generally not be permissible and could be viewed as retaliatory under the law, so you want to make sure to update those as well. Do you buy back or pay out unused time at the end of the year? And this is a cause for concern just because employees must be allowed to carry over all unused time and they cannot be paid out instead. So you'd want to update your policy to reflect that as well, that no buyback or payout is permitted. Next, do you have an attendance bonus? Attendance bonus policies, while they're viewed as a bonus or beneficial, could potentially be viewed as discriminatory or retaliatory for those that choose to utilize this sick leave. So we would also recommend just removing any kind of bonuses that incentivize employees to not use their sick or safe leave. And the last one, is it prohibited to use paid time off during the notice period immediately preceding a resignation? And if the reason for use is a reason under the sick leave law, then when an employee takes a sick leave or safe leave day, it cannot be prohibited even if it is during that resignation period or immediately preceding an employee's last day. That would not be okay under the law. They are allowed to use their sick and safe leave up until they terminate employment. All right, moving on to some frequently asked questions. So I'm just going to run through these question and answers. Are nonprofit employers exempt? The answer is no. Nonprofit employers must comply with the sick and safe leave law. Next, does an employer have to provide sick leave to employees who telecommute outside of New York State? And the answer to that one is employees who telecommute are covered by the law only for the hours when they are physically working in New York State, even if the employer is physically located outside of New York State. So you would only have to provide that sick leave to employees who telecommute if they are in the actual state of New York. Next, if an employer has multiple business locations within New York State with 4 or fewer employees at each location, does the employer have to provide paid sick leave under the law? And the answer to that one is to determine the number of employees in this scenario, the employer would count the total number of employees across all locations. So for example, if there were 3 employees at one location, 4 employees at another location, and then 7 total employees, you would be required to provide up to the 40 hours of paid sick and safe time in each calendar year for each employee. So you just want to make sure to account for all employees at all locations. More questions? Does sick leave include bereavement leave? Can an employee use accrued sick leave when there is a death in their family? So the permissible reasons to use accrued sick leave and safe leave do not include a period of bereavement, but employers must provide sick leave for mental or physical illness, injury, health condition, and regardless of whether they have been diagnosed, as well as for the preventative care for such illnesses. So bereavement is not specifically covered under the law. And next, can an employee use safe leave if the police have not been contacted or the perpetrator has not been convicted? The answer to this one is yes. An employee's eligibility for safe leave is not dependent on reporting to law enforcement or a criminal conviction. Next, does paid sick leave transfer if an employee is promoted, demoted, or takes a different position within the company? And the answer to this one is yes. Leave accruals may not be reduced or otherwise restricted if an employee changes positions, roles, or locations with the same employer. The paid sick leave under the law must be paid out at an employee's rate of pay at the time that the leave is taken. And I am going to turn it over to Brianna for some more FAQs.
Thank you. So some of these I've already addressed. They've been addressed throughout the presentation, but just to reiterate, I will go over them quickly. But the first question, if an employee uses leave during hours that would have been overtime if worked, does the employer have to pay the overtime rate of pay? So as I mentioned earlier, no, employers are required to be paid their normal rate of pay for leave time under the law. So any overtime hours that are taken for paid sick leave, they would just have to be paid at their normal pay. It wouldn't have to be that overtime pay. So the second question, are employers required to pay employees for lost tips and gratuities during leave time? Again, no, employers are not required to pay employees for lost tips or gratuities, but employers may not take a tip credit for leave time and must pay the employer their normal rate of pay or the applicable minimum wage, whatever is greater. Question number 3, can an employer require that an employee locate a replacement worker to cover a shift or job if the employee elects to use their sick leave? This would not be permissible. So long as an employee is using the sick leave for one of the reasons that I described earlier, that's covered under the law, an employer may not require additional preconditions. Moving on. So how much notice does an employer have to give? So I discussed this earlier. There is no specified notice or time period requirement under the law, just that an oral or written request to the employer prior to using the accrued sick leave, unless otherwise permitted by the employer. So just prior notice to using the sick leave is required. That is the guidance that we know to date. So may paid family leave be used consecutively with paid sick leave? Example, 3 days of paid sick leave, 2 days of paid family leave. So to answer this, an employee can only choose to use sick leave during paid family leave if the employer allows it. So taking sick leave at the same time as paid family leave may allow the employee to receive their full salary for all or part of the leave. However, it's important to note that an employee cannot receive more than their full wages while receiving PFL benefits. So if an employee is taking paid family leave, and they're going to supplement paid sick leave, if the employer allows it, they wouldn't be allowed to take time so that they would be receiving more than their typical wages. So that's just something important to note. In the final slide, can an employer have a policy that permits employees to donate unused leave to other employees? So this would be allowed. So an employer can have a policy that allows employees to donate unused leave to other employees, but the policy has to be entirely voluntary. And do employers need to pay employees for unused leave at the end of the employment relationship? And we did discuss this. It is not required unless the employer has it indicated in their policy. So however you want to indicate, if you want to pay out for resignation for employers who give 2 weeks notice, or if you want to pay out at retirement, you would just need to indicate this in your written leave policy. So if you don't want to pay out for any time, make sure you include non-payment language in your written policy. And something important to note is for seasonal employees who maintain an ongoing employment relationship with their employer, they would maintain their leave accruals through such breaks in employment. So if you have a seasonal employee who you lay off, they're getting unemployment, but they have an anticipated rehire date, and this is something that you lay them off, they come back, you lay them off, they would keep their accrual amounts for when they return. So just keep in mind, if you have seasonal employees, that when they return, they would have to, their accrual amounts would be reinstated if they had any sick and safe leave when they were laid off for that season. And I will turn it back over to Casey now.
Great, thank you so much. Thank you, Rachel and Brianna, for all of that really great information, and certainly we thank you all for attending. Those were some of the FAQs that New York State has issued, and as we mentioned, we do anticipate New York State releasing additional FAQs, additional guidance, and certainly the final regulations also at some point. So we do certainly encourage you all to, visit New York State's website, monitor, check the FAQs. We certainly will be monitoring updates as well, and we'll be providing updates as appropriate. But the FAQs are, as of right now, a really great source of information, and will hopefully be helpful to all of us as we're navigating through this new law. And as we mentioned, with the final regulations, it's our understanding that they could take, up to a few months to come out, but certainly, we recommend to move forward with everyone's policies. Employees are entitled to use the leave, the new law, beginning 1/1 of 2021. So, it's important to revise policies based on what we know, and just know that there's most likely more to come. But certainly, it is important to move forward, get those policies out, and make sure that employees acknowledge them as well. So again, thank you. Should you have any questions, we have our email address up here, which you are certainly welcome to submit any questions. We invite you all to submit any questions that you may have. It's OneGroup Consulting at onegroup.com. We will be monitoring the inbox and, happy to help and provide responses in a timely manner. So again, thank you so much for attending. We hope that you found this helpful. Please don't hesitate to reach out with questions. And thank you. Have a great afternoon.